To elect S status, you start with eligibility, because a perfect Form 2553 can still be invalid. The corporation must be domestic, have 100 or fewer shareholders, and generally only eligible shareholders: U.S. individuals, certain estates and trusts, and some tax-exempt organizations. No non-resident alien shareholders. And the one class of stock rule means identical distribution and liquidation rights, even if voting rights differ. On the EA exam, they love the Form 2553 timing rule. To be effective at the beginning of the tax year, Form 2553 is due no later than the 15th day of the third month of that year. That's the famous 2 months and 15 days after the start of the year. If you miss it, you're generally not S for that year unless relief applies, but the exam usually tests the basic deadline. Effective date questions often hinge on whether there was a prior tax year. A brand new corporation can't file a valid S election before it exists. So if it incorporates on January 9th, the election window starts January 9th and runs 2 months and 15 days from the start of its first tax year. But an existing C corporation can file during the prior year to make the election effective next January 1st. Shareholder consent is a trap. For an S election, all shareholders must consent, and if the election is made during the year it first takes effect, each person who held stock at any time during that year must consent, even if they sold before the election was filed. So someone who owned shares on January 1st, then sold in February, may still need to sign Form 2553 for a calendar year election effective that same year. Now contrast that with ending S status. Revocation doesn't follow the same everyone must sign idea. If shareholders holding more than 50% of the shares consent to revoke, the S election can be terminated. On exams, watch the wording. Electing S status is unanimous consent, but revoking S status is majority control. That difference shows up in fact patterns with one controlling shareholder. Once you're an S corporation, compliance is annual. You file Form 1120-S and you issue Schedule K-1s to shareholders for their pass-through items. An S corp must file a return even if it has zero income or a loss until it's legally dissolved. The return is signed by an authorized corporate officer or sometimes a fiduciary like a trustee or receiver. Deadlines are straightforward but heavily tested. Form 1120-S is due the 15th day of the third month after year-end. For a calendar year S Corp, that's March 15th. If you need more time, file Form 7004 for an automatic 6-month extension to file. Remember, extension to file, not extension to pay any tax that might be due at the entity level. Which of the following would be a tax advantage of a multi-member LLC that operates as a partnership over an S corporation? The choices include tax-free liquidation, fewer requirements for boards and meetings, no self-employment tax requirement, and the same liability protection as C Corp shareholders. Think about which one is a real partnership versus corporation advantage. The correct answer is no requirements for a board, regular meetings, minutes, or other formal administrative structure. A partnership-taxed LLC generally has fewer corporate formalities than an S corporation. A tempting wrong choice is no self-employment taxes, because S Corp owners may reduce SE tax on distributions, but that's not no requirement, and reasonable compensation rules still apply. Which of the following would make a corporation ineligible to elect S corporation status? The options include a bankruptcy estate shareholder, a partnership shareholder, exactly 100 shareholders, or having both voting and non-voting stock. Think about the shareholder eligibility rules and the one class of stock rule. The correct answer is one shareholder is a partnership. Partnerships are not eligible S corporation shareholders. A tempting wrong answer is having both voting and non-voting stock, but different voting rights are allowed as long as distribution and liquidation rights are identical, so it can still be one class of stock.